No, and in fact, there's actually a pretty good jab in the complaint here from Firearms Policy Coalition that if King George tried to force a registration on the colonists, I mean, that would have kicked off the revolution immediately.
Well, I mean, the revolution was started by an act of gun confiscation.
It was.
So,
but maybe it would have pushed the timeline up.
But yeah.
We are the Armed Attorneys. Today we're talking about a huge lawsuit when it comes to the National Firearms Act. Now this is, we see the big beautiful bill, suppressors, short-barreled rifles, shotguns, AOWs, tax reduced to zero. We've already seen some action on this front from JUA, but we have a bunch of other gun groups stepping in now. We're going to be talking about all that and more, but before we begin, show your support for the Second Amendment by hitting that like button. And we'll give you the link to the case. We'll throw that down in the show notes. But if you want to follow this case, it's Brown v. ATF. This is case number 425 CV01162. This is in the Eastern District of Missouri. So we have this lawsuit being filed by some individual plaintiffs, Prime Protection, STL Tactical, Boutique, and NRA, Firearms Policy Coalition, Second Amendment Foundation, ASA. So a lot of gun groups have jumped on this case, and they're not first in, maybe best dressed. We'll see what happens, because we have two of these lawsuits now. One primarily championed by Gun Owners of America, this other group. And what are they focusing on?
Well, they're focusing on the point they're focusing on the fact that the tax has been removed from these NFA items. And what, some of our viewers may or may not know is that the NFA is a tax law. It is not specifically a weapons law. If it were a weapons law, then it would be found in 18 USC 922 along with all the other weapons laws. But it's not. It's actually found in the tax code portion of the U.S. Code. And so the argument is, say, look, if there's no longer a tax, then why on earth can the regulation exist?
Well, the government loves them some hoops. And that appears to be the best argument. I'm making air quotes here, eyes rolling if you're just listening. Because what we imagine will happen, start of the fiscal year 2026, effectively with these taxes being reduced to zero on suppressors, short-barreled rifles, short-barreled shotguns, and AOWs from $200 or $5 for AOWs down to zero. What's the purpose of all these hoops? And it seems like the government just wants people to waste time and energy.
Well, what they really want is data collection.
Yeah, it's a registration.
They really want to know who has the short-barreled firearms, who has the suppressors. That's what they, that's their whole purpose of maintaining this, rather than just, what the big beautiful bill should have done. Should have just drawn a big red line through the whole thing.
Yeah, big time. But all right, well, why attack this direction? Well, we see the NFA is completely supported by case law that says the scheme is based on Congress's legitimate authority to tax. Well, when that tax is zero, what is Congress left with?
Right, because the NFA has never really been attacked on Second Amendment grounds.
No.
And so it's always been, does the Congress have the power to tax this? Does it constitute interstate commerce? It's been all these other issues about dealing with the regulation, not does the NFA violate the Second Amendment?
Well, and this one does both. So obviously, if Congress hasn't taxed it, well, and this is what lawyers do. They say, they make a bunch of arguments in the alternative. Well, obviously, if this isn't a tax anymore, can't be supported by law. They do attack Commerce Clause, basically, hey, folks, think about Texas. I'm going to make this thing wholly in my house. I have no intention of this crossing state lines. How would the National Firearms Act, how would that even invoke the Commerce Clause?
Right, because that's what it was. It was a tax on interstate commerce. And Texas has most recently been one of the states that's passed the homemade or Texas-made suppressor law. There's been a couple of other states who have done that, in which it has been struck down under the supremacy clause. But it brings up the issue of, if something does not affect interstate commerce or has no effect on interstate commerce, can it legitimately be taxed? Now, we could have a whole nother video about the machinations of the Interstate Commerce Clause, so don't run to the comments and say, well, what about
Wickard v. Filburn?
What about Wickard v. Filburn? What about dropping the bucket? What about effect? So,
do you remember the name of the barbecue case? I think it's out of the Carolinas.
Yes, it was.
That one is the one that I think turned me into basically almost a anarcho-capitalist.
Well, yes, and that case I believe was Katzenbach versus McClung. And yes, for those of you who don't know, the 1964 Civil Rights Act, the public accommodation portion, which affects only private citizens, was attacked immediately upon passing in 1964. And that was the argument. It's like, you can't regulate us. We're not involved in interstate commerce. We're a barbecue place that's in the backwoods of South Carolina.
Yeah.
We don't get interstate customers. We're not on a highway. We don't advertise.
Didn't they pull in their napkins? Didn't they say, no, look, you ordered napkins?
It was the salt.
Oh, that was it.
Yes, which is weird because they probably could have got their salt within South Carolina, but they go like, nope, you buy your salt from interstate commerce, therefore we have the authority to regulate you.
That was a fun sidebar. But back to the case at hand, the National Firearms Act. So we see, all right, maybe the best argument so far, and we haven't even got to it yet, was the National Firearms Act is a violation of the Second Amendment. We look at the text of the Second Amendment as informed by history and tradition. Is this something that the Congress would have regulated or legislated about at the time of the adoption of the Second Amendment in 1791? No, and in fact, there's actually a pretty good jab in the complaint here from Firearms Policy Coalition that if King George tried to force a registration on the colonists, I mean, that would have kicked off the revolution immediately.
Well, I mean, the revolution was started by an act of gun confiscation.
It was.
So,
but maybe it would have pushed the timeline up.
But yeah, the colonists, they loved their short barrel firearms. Loved them. Blunderbuss, anybody? So yeah, they would not have stood for this. And it's such an illogical regulation anyway, considering suppressors as weapons. That's completely illogical.
Well, to have them, and this is pointed out in the complaint, so this isn't, I'd love to say this is my idea, but no, they did a great job pointing this out. Treating suppressors and machine guns the same is ridiculous.
Totally ridiculous.
So, all right, what do the plaintiffs want in this? Well, obviously, we want to invalidate the National Firearms Act with regard to these items we've already talked about, SBRs, SBSs, AOWs, suppressors. Maybe this gives us a new line of jurisprudence where we can make other attacks on Second Amendment infringements. I think that's what they're looking at. You know, they want a declaratory judgment against the federal government to restrain them from enforcing the National Firearms Act from all these folks. Obviously, they want attorney's fees. But this is, I mean, there's a couple of attacks going on to the NFA, Gun Owners of America with their case, and these folks with this case. I mean, something's going to happen.
Oh yeah, and it's logical. Of course, that was everybody knew this was going to happen. This was not a surprise to anyone. I guess the only thing really surprising is that there should have been recognition that this was probably something that should have been done in the legislation instead of leaving it up to the courts, since the courts are kind of a mixed bag, and it does take years because this will eventually, it should theoretically.
During J.D. Vance's second term, this will probably be resolved.
It'll go to the Supreme Court, maybe, unless they deny certiorari like they do in gun cases. But we'll see. Hopefully we won't wind up with a patchwork where the Fifth Circuit says NFA doesn't exist. Fourth Circuit says, no, it absolutely does exist and should be enforced with all due haste. But we'll see.
Yeah, but we hope you enjoyed this discussion. If you did, consider subscribing, hitting that like button, and help us fight the anti-2A algorithm by sharing this video. And always leave your questions and comments in the section down below. And until next time, we're the Armed Attorneys. We are the Armed...
Huh?
You ready?
Yeah.
All right.